Rise and give your attention. The Honorable Justice of the Gas Department.
Please be seated.
The court is now in session.
Morning. This is number 2234, Lustre Oil Anadarko. You notice that we 6 this morning. Just discussed something available this morning, but he is participating in this. We'll be looking at your Morning. Yeah, Bill Clark, attorney currently looking at. With me, I have Andy Patton, Billings. Also, I have John Stafford with me, who's here on behalf of Lustre Oil Company, Montana LLC, and EREHWON Oil and Gas. Hopefully, going to reserve about 10 minutes for the process. And what started off as a pretty simple, quiet title action involving some oil and gas leases turned to a relatively more complex case of sovereign. So with that, I'm going to address 3 primary arguments. First, did the district court properly find that it lacked subject matter jurisdiction in an LLC formed exclusively under Delaware law and solely under Delaware law, in which disclaimed sovereign immunity actually possessed. We maintain that this court should follow the well-reasoned analysis of Summerlot Cherokee Nation because it's good and sound reasoning. The Summerlot case out of the 10th Circuit properly determined that an entity owned by a tribe but exclusively formed under the laws of another state sovereign lacked, as a matter of law, sovereign immunity. Here it's undisputed that the tribes, in this case, deliberately and freely chose to incorporate their LLC in Delaware. Second main issue I'll address is the white factors based on the case White versus University of Delaware. We maintain that the district court improperly applied second, third, and fifth factors in that test. We'll also discuss some of the other factors. First, fourth, the district court weighed and determined not weigh in terms of finding a sovereign immunity. Last, third main point, the district court ruled that Lustre has a recourse to tribal court. Under the district court's holding, A&S, however, is immune from all suits in all courts, including the tribal courts on reservation. So with that introduction, we will request that this court overturn the district court's order that found A&S possessed sovereign immunity as an arm of the tribes, and that it does actually possess subject matter jurisdiction. Before getting into those 3 main points, I wanted to briefly discuss some of the factual backgrounds and factual issues that have come into this case as discussed in some of the briefs. First, all of the lands, all of the oil and gas leases, all of the oil and gas wells are subject to the suit private. Private mineral owners, private surface, lease their minerals to private oil and gas companies. Montana Board of Oil Gas Conservation has exclusive jurisdiction over those oil and gas wells. This case originally centered on these non-Indian owners who leased their minerals to a non-Indian corporation. Then A&S stepped into the shoes of that other private corporation. Those leases terminated years ago for lack of production, lack of payment, all under the previous operator, Anadarko Minerals. Lustre then obtained new leases from these same mineral owners. Second major factual issue we'd like to discuss, that the district court improperly relied on issues involving environmental regulation of the tribes. And the allegations of prior bad acts by these unrelated third parties having really no bearing on this case, which centered on quiet title action. There's also been some discussion as to whether or not.
On that, I see from the district court's order, and I don't think you dispute that A&S has also assumed responsibility for the tribe's restoration and cleanup efforts, and abandoned well sites, and some other things that do involve environmental regulation. And I guess my question is, what if a claim arose against A&S for those activities? Would the immunity argument be different? And kind of a follow-up on that, can there be immunity for one purpose and not?
We don't believe, to your second question, we don't believe it. We believe that based on the documents in the record, the 4 tribal resolutions and the 2 formational documents, the operating agreement of A&S, as well as the operating agreement of Fort Peck Energy Company, those are the stated foundational documents about the stated purpose of A&S. Not a single one of those documents references environmental cleanup, environmental regulatory authority. In our mind, that is a post hoc rationalization regarding who came into an application. Now, listen, we understand that every tribal entity in the tribe itself, they are going to support environmental regulation. We don't dispute that. But A&S, oil and gas operators, they operate and they drill and they operate oil and gas. They went to the MBOGC and became a registered operator and were bonded to the MBOGC. So from the stated purpose of the documents in the record, they are simply an oil and gas operator. So
What about my first question? If a claim arose against A&S from restoration and cleanup efforts at, say, an abandoned well site, what then?
we would maintain that based on those same documents, they do not possess something because they are simply an oil and gas operator. And the tribes themselves have their own minerals department, which is a regulatory sort of sub-agency of the tribes. They delegated that authority. But we just discussed that they are registered and bonded in the agency. There was also a point in some of the briefing about the Safe Drinking Water Act and how it applies to this case. Under that statute, EPA has designated the tribes as a state to regulate underground injection and water injection wells. And in this case, there are no water injection wells issue. There is simply no jurisdiction under that statute into wells and issues, wells and leases at issue. It's completely irrelevant. So back to my first main point, court should follow summer law. As a Delaware LLC and subject to Delaware law, this court should hold, consistent with the reasoning summer law does not possess sovereign immunity as a matter of law. Reasons for that is primarily discussed in the concurrence of justice that A&S made a voluntary and free choice not to form that LLC under tribal law, to go to Delaware and form it under Delaware law. And as we know, people form LLCs for a variety of reasons. One of those is to enable them to subject certain assets to liability, certain assets, personal assets, to be protected. So what A&S was doing is going to Delaware, creating an LLC, and thereby protecting the tribe's assets from any liability. That's very clear throughout all of these documents that we want to separate the two. A&S's assets at risk, not the tribes.
Council, can you address the subsequent precedent, I think some district courts, and quite frankly, summer law, the issue of, I mean, the argument is that the immunity discussion is different because it hasn't been.
You know, this idea of dicta, I think, is somewhat of a dinosaur, in my opinion. The decision in summer law was a 1.5-page analysis. Then Justice Gorsuch went through a 5-page analysis on why that entity should not have tribal immunity. I don't consider that dicta. consider that just the court's sound reasoning. Ultimately, it did not become the holding of the case simply because it was not raised at the court below.
Well, isn't that the definition of dicta?
Yes, I assume. But that doesn't change the reasoning and the analysis. And I'm not saying that the summer law is binding on this court. I don't think any Ninth Circuit decision or a 10th Circuit decision is binding. I think the district court made it very clear too, in relying on Pete and Mark Gibson to say we're going to defer to the Ninth Circuit. Those cases say let's defer to federal courts. So I'm not suggesting that it's binding. I'm saying that the reasoning is sound. It's good, awful analysis of why we should follow that particular case. And so if you look at the reasoning, the main reasoning there was that Justice Gorsuch went through was that they made that free choice. We need to respect that. That's part of their self-governance. That's part of their self-authentication. They make those free choices. We should respect those free choices. They can't go to Delaware and enjoy all the benefits of Delaware law in terms of taxation. The Chancery Court in Delaware, a very well-developed court in terms of LLC law, but then at the same time say, we're going to subject ourselves to another sovereign. But then we're going to come back to Montana. Now we're completely immune from suit from anyone. So I think that's really the holding in Summerlot. I think that's most important. That if they made that free choice, we need to respect the choice. There's also been some other cases discussing Summerlot, and we think that have gone back and forth. The Ninth Circuit decision in McCoy, again, that did not address the issue in Summerlot. In McCoy, both of those entities formed under tribal law. That's not what we're talking about. We're talking about a situation where exclusively and solely under another state's sovereign.
Counsel, what's the real significance of that? Because I understand there are attributes of Delaware corporations that are advantageous to people who incorporate under Delaware law. But the basic concept of the corporation is the same, whether it's under Delaware law or Montana law or some other sovereign's corporate law. So what's the real essential significance of the distinction between saying on the one hand, or at least seemingly tacitly acknowledging that there would be tribal immunity here if this corporation was incorporated under tribal law, but it's not because you went and got your incorporation charter from another sovereign. Yes, they did, and that's the hinge point in Summerlot, but why is that significant?
I think it's significant because we're looking at the fundamental nature of this sovereignty. We're going to protect it as a sovereign nation. They have their own laws, and we're going to protect and respect that. If they want to form under tribal law, they are staying within the confines of their own legal system, their own laws. When they choose to go outside of that, they voluntarily and on free will go and they become subject to another state's sovereign. So they're getting the benefit of another state's sovereign, so forming a separate entity. This is what Gorsuch is really talking about.
But here, and I understand that, and I'm not disputing that point, but it seems that, yes, that's a factor, but there doesn't seem to be any dispute that as to, based upon the documents, as to what the purpose of this corporation was, that it's controlled by the tribe, that it's essentially an instrumentality of the tribe, at least de facto it is. And do you dispute that point?
I think we do, for a couple of reasons.
On what basis?
So if you look at the original tribal resolution that created A&S, they said as part of that document, one, we're going to aggressively pursue oil and gas, not aggressively pursue environmental, aggressively pursue oil and gas. We're going to go and we're going to get into business relationships, other creditable, companies that can get credit, companies that are business solid. We're going to go to Delaware. We're going to join a separate LLC called the Fort Peck Energy Company LLC. We're going to do that with two other non-tribal entities, NARC and Quan. To do that, in order for these companies to contract with us, we have to go to Delaware to do that. So by doing that, you look at these fundamental foundational documents, that's really what's occurring. And now that's the original purpose.
Excuse me, and I agree with you about that characterization of the factual record here, but still at the essence of that, what's happening is the tribe is clothing itself in its legal structure in order to do business in that business environment. But how does that change the essential nature of that corporation as an instrumentality of that tribe?
I'm not sure I can completely understand the difference there with your question.
Well, it's controlled by the tribe. It's chartered by the tribe. There's no, and for what are on the face of those documents, tribal purposes.
Disagree. It is not chartered by the tribe, authorized by the tribe. They went to a separate sovereign.
Fair
it's
enough.
Chartered by Delaware law. It's subject to Delaware law.
But this is authorized. The Delaware charter of this, for this purpose, is authorized expressly by the tribe under tribal law, or what the tribe views as tribal purposes. Is that not accurate?
If you look at some of the documents in the record, I don't think that it is. If you look at the documents in the resolution, they're saying we are going to separate the tribe from this entity. If you look at these resolutions, we want to separate those. Now, they may be owned and controlled by the tribe executive. The resolutions make clear you're going to separate these things. You're going to separate them. And in doing so, when they executed the Fort Peck Energy Company operating agreement, they said, as a Delaware LLC, we are not a sovereign entity. That's what they said. It's not a waiver. They said, we are not a sovereign immune entity. That's what they wrote. That document, the acknowledgement in the waiver at Appendix 115, that's it.
Tell me where that's at again. I'm sorry.
Page 115. This is a separate acknowledgement and waiver executed by the tribal executive.
Resolution 2009.
Maybe I have my citation. I'm sorry, 137.
This is the March 23rd, 2009 acknowledgement and waiver.
March 12th. March 23rd. Yes, correct. So this is a document that was executed 11 days after the Fort Peck Energy Company LLC, and exactly 14 days after the resolution approving A&S. It's a foundational document. It's right there at the same time. And in this document, if you look at number 1, the Assiniboine and Sioux Tribes hereby acknowledge, it's not waived. Tribes holding company, that's defined as A&S, does not and shall not be construed to possess sovereignty. Period. This is not a document executed by A&S. A&S can't waive its own sovereignty. It's a document executed by the tribe. The tribe is saying, as a Delaware LLC, we are not going to be sovereign. They then go on to say, out of abundance of caution, remove all doubt, and irrevocably waive any right to otherwise might have to assert that we're sovereign. So they're not waiving sovereign immunity. They're saying we are waiving the right to even assert we have sovereign immunity. That's another big distinction in this acknowledgement. This is why this document is so
They're
important.
saying that we don't have it in the first instance.
In the first instance, A&S is saying in this document, executed by the tribal executive board, we never have and never will have sovereign immunity. Period. End of that's what they're saying.
Right, the argument that A&S is making at the very beginning of that acknowledgement and waiver, it says it's entered pursuant to the section 10.16 of the limited liability company agreement of Fort Peck Energy Company. So the argument is that it's tied to that Fort Peck Energy Company formation and agreement, which in its provision says it doesn't grant any rights to third parties. So can you address that and how it affects the right to claim waiver?
Let's look exactly what 10.16 says. This is appendix 115. It has the same language. As a Delaware LLC, A&S shall not be construed as possessing sovereign immunity. It's the same language. And that's not what we're arguing. We're not arguing that we are a member of this LLC and that there was a waiver to us. That's not the point of this argument. The argument is that this is a separate acknowledgement. Never have, never will have sovereign immunity, never have the right to even assert we have sovereign immunity. The only way NARC and Quantum was going to execute this document is if they had assurances that they could hold A&S accountable in court. That's why they went to Delaware. It's very clear from the resolution that says, in order to conduct business with a credible oil and gas company, we're going to go to Delaware and form the LLC. That's why they did it.
So I guess I'm missing the distinction. The federal precedent is in terms of waiver language, that unless the tribe waives it. So what's the distinction between saying we're not going to exercise it versus we're waiving it?
Okay, I think the distinction here is that we're not a party to these agreements. And Lustre and EREHWON are not a party to this agreement. These agreements, these are the foundational documents. They're now saying, we are the same thing as the tribe. We're the arm of the tribe. And our point is that under Summerlin, they're acknowledging that Delaware LLC was never going to have sovereign immunity. That's why we think this is applicable. Because we're not necessarily, I know we may have argued a little bit about the waiver. That's not the
All right, can I get to one aspect of Summerlin and wait? It's, I get Summerlin and corporation under another state sovereign to waive that immunity. But you address Judge Thomas's analysis in White River, where he says the district court also properly concluded that the repatriation committee did not waive its sovereign immunity by filing suit or by incorporating under California law. And then he says, subsequently, we have previously rejected the plaintiff's alternative argument that a tribe's decision waives its sovereign immunity.
In that case, they incorporated it in the state law after they'd already formed under tribal law. What those cases are talking about is an instance where you form your LLC originally under tribal law, then for some reason you go and you incorporate or form under a state law. And by doing it under state law, you're thereby not waiving that right. This is the Williams case. There's other cases that talk about that distinction as well. I'm not aware of any case, they cite to none, in which, other than the District of Oregon and maybe the Hunter case, you have an entity exclusively formed under state law being held in the Summerlin analysis, the Summerlin line of cases to have sovereign.
He cites to American Vantage companies versus Table Mountain.
So I'd like to move on a little bit, if that's okay, and kind of get to the actual life factors. We must certainly think that this court should follow Summerlin and say, based on the acknowledgement, separate acknowledgement, based on the analysis of Summerlin, that they do not.
That's why I wanted to come back to this, is that, because I think, at least under this purpose factor, relevant factor here, or White, this goes back to the question I think that Justice Baker was asking here earlier, in general anyway, as to whether or not you think there can be a waiver for one purpose, but not for another.
I don't believe.
Why not?
Well, no, I think that usually a waiver is in a specific contract related to a specific party and specific issue. So if we were to execute a new contract with, say, a joint venture on developing these leases over here or these leases there, we go through and we say, we want to have this joint venture contract with A&S, we need a waiver. So yeah, a limited waiver obviously occur in any contract. So they can waive sovereign immunity in one contract, but then still maintain their sovereign immunity as to other issues. That happens every day.
Isn't that what they're saying they did with the FPC operating agreement?
I think that's what they're saying. But that argument is not talking about the statement that they do not possess it in the first place. So if there is a waiver, I think the argument would be that the waiver applies to the other entities, Quantum and NARC. That's not our argument. Our argument is that it is a statement, it is a matter of law. They're saying we are not, shall never be a sovereign entity, or we shall never possess sovereign immunity. That's what they're saying.
So under the acknowledgement and waiver, you're relying upon number one, the acknowledgement, and you would concede then that number two is the quote unquote waiver is constrained to the agreement between A&S and the LLC operating agreement.
I think that has to be.
Before you move on, I'm trying to keep Patrick about this. I think it's important. Is that I understand your point based on that language that they're making that broad declaration, but you have to look at that in context. Do you not? And are they not, as you indicated or described it here today, making that declaration to allow a certain scope of potential liability with these people who are engaged in contractual relations?
I do not. I agree with that.
You do or you do not?
I do not.
Okay,
I think
tell
that
me
you
why.
cannot limit it because it's a declaration and an affirmation from the tribes, the tribe executive board. It's not from A&S saying its purpose. It's not A&S saying purposes of this agreement. They do say that purposes of this agreement, we are waiving it to NARC. This is a declaration and an acknowledgement, and it's in the agreement itself. We do not possess.
But why are they saying that it doesn't pertain to the context in which they are acting here?
I think they had to do it to give assurances to NARC. I wasn't there. It was in 2009. I think they had to give it. And this is what the documents show. If we go back and you look at the four resolutions, they're all talking about this concept of we're going to separate the tribe and separate the entity so that they can go and do oil and gas and have credible partners, go do these things separate and distinct from the tribes. Go look at these actual four resolutions. That's what they're saying. And so this acknowledgement in our mind is further proof that that is actually the case. So, I can look at, go back real quick to the purpose factor. I think this is where we think the most issue with district courts. We obviously think that the court got the first factor method right. I don't think any dispute they went to Delaware, method of creation in Delaware. But if we go back and look at the appendix 60 and 61, this is the original tribal revolution. Purpose to aggressively develop the tribe's resources. Okay. Purpose is to go join the Fort Peck Energy Company LLC. The purpose is not to regulate aggressively oil and gas. And you can look at the next resolution, appendix 62. The purpose is to shift liability to ASME, to A&S. That's the purpose. We're going to shift all liability to A&S. It's not going to treat them as one and the same as the tribes themselves. We're going to shift all liability. And then you go to the A&S operating agreement, section 6.2. All the liability and obligations of that of A&S, not of the tribe. Again, we're going to shield A&S. So we're going to shield the tribes. We're going to push everything to A&S. These are the foundational documents. This is what the true stated purpose was. And again, if you go look at we talked about the Fort Peck operating agreement, again, executed within days of these tribal resolutions. That was the purpose. Acknowledgement, not to be sovereign. Let A&S take all the liability. We're going to protect the tribes. We're not going to treat the A&S as the same as the tribes. We're going to shift all that liability down. Express purpose of protecting the tribes. That's why they can't share in their sovereignty. Again, and so as we know, that was all in 2009. The Fort Peck Energy operating joint venture ultimately did not proceed. So they reinvented in 2020. You look at those resolutions, it's appendix 142 and 143. Again, even in 2020, they're saying we're going to insulate the tribe from all liability. That's the stated purpose. Stated purpose is not regulate oil and gas. Purpose is not, we're going to treat A&S the exact same as the tribes. We're going to insulate the tribe. Same thing said for resolution 964. And it's one, we're going to operate mineral development separate and distinct from the tribes. Again, there's no other stated purpose in that document. So that as to the arguments and as to the second element, we think the district court made fundamental errors by looking at beyond the stated purpose. It gave it a third purpose, but we think that that is the fundamental error of the purpose analysis, that it's going beyond what the tribes themselves are stating, 09 as well as the 20. As to the third factor, just one point here. Again, when we're talking about management of the A&S, if you look at the 2020 964 Appendix 144 resolution, again, it's saying we're going to separate all government functions from the oil and gas functions. To me, that doesn't sound like we're going to treat them one and the same. We're going to separate them. That's why we think the district court got it wrong on that case, on that factor. Thank you. And I think the same can go for the operating agreement. This is Appendix 72. A&S's obligations and liabilities all first on account. We're going to keep A&S's obligations, liabilities all on A&S. As to the factor, I'll just make one quick point. District court really looked at three different issues, or three different characteristics in the Miami Nation case, and they only actually looked at one. And if you look at the other two factors that are detailed, and that case has a lot of precedent value, goes into a lot of detail. That's kind of it's if a judgment against the entity refutes the tribe's assets, here's no. The tribes has made it very clear that A&S's liabilities, that's all on its own. No judgment against A&S is ever going to reach the charge to retrieve more assets. Institutional documents have made that very clear. So the district court erred by looking at that, not looking at those two issues. And as to the one issue that it did look at, it said that $61,000 a month is a significant amount of money to the tribes, to the overall budget. Did no analysis. It looked at solely at the numerator, not look at the denominator. Tribe's annual budget is millions. So $61,000 we don't think is a significant amount of money, just for purposes of this analysis. Just one more minute, and I'll reserve the rest of the rebuttal. But we also think, it's to our last point, that justice really does require A&S to be subject to civil liability. The district court erred in our mind, saying that, well, Lustre, you can just go to tribal court and you can adjudicate your rights there. That is simply not the case. A&S cited to section 107 of the tribal code, which is jurisdiction. We don't dispute for jurisdictional purposes that tribal court has jurisdiction over the tribe and A&S. Section 110 is really important. Section 110 unequivocally states that the tribes have immunity in tribal court. If the tribes have immunity in tribal court, so does A&S. A&S has not waived its sovereign immunity in tribal court either. They acknowledge this in page 40 of their agreement. They say that A&S, or that Lustre, has no forum to bring these claims against A&S. So under the district court's holding, A&S is immune all suits. We don't think that that's fair, right? Intended consequences of what this case should be. So in sum, allowing a Delaware LLC to operate oil and gas wells, private lands in Montana, but to be completely impugned from suit in any court in the state, we think is not the proper remedy or the proper. With that, I'll reserve it.
Murdoch.
Good morning, Chief Justice and members of the Montana Supreme Court. I am Matthew Murdoch for Appellees, A&S Mineral Development Company and Anadarko Minerals Incorporated. I'm here today with my colleague, Ryan Rushi, from Sinosity Chambers, Association. And I'm also joined today by members of the Fort Peck Executive Board. And I'd like to recognize Chairman Mazurek of the Fort Peck Tribes, Councilman Justin Greyhawk, Councilwoman Carolyn, Councilman Bryce Kirk, Councilwoman Stacy Summers, former councilman and chairman of the A&S Mineral Development Co. Deb Madison, longtime tribal employee, general manager of the A&S Mineral Development Corporation Company, and Chair Old Elk Stewart, current in-house attorney for the Fort Peck Tribes.
Thank you. Dr. Hall.
This court should affirm the district court's dismissal of Lustre's action. First, the district court was correct to find that A&S is entitled to sovereign immunity as an arm of the Fort Peck Tribes. A&S is wholly owned by the tribes and exclusively controlled by the tribes. All of A&S's profits are distributed to the tribes to fund the tribal government. And the tribes formed and used A&S to further important governmental objectives, economic development, as well as to protect against the type of environmental degradation that has occurred on the reservation in the past. In short, the district court was correct to find that A&S functions as an arm of the tribes. As to the second issue, the district court also correctly concluded that A&S is not expressly and unequivocally waived its sovereign immunity for Lustre's claims. Lustre is a stranger to the tribes and A&S. Lustre has no prior involvement with the tribes, A&S, and the reservation. Finally, the district court was right on the final issue to dismiss the action in its entirety because A&S is a necessary and indispensable party. The suit cannot proceed without A&S. And if I may, I'd like to start by addressing Lustre's first issue to discuss, which was whether A&S's formation under Delaware law is dispositive with respect to the issue of sovereignty.
The tribe has immunity in tribal court. So does A&S. Is that true?
With respect to Lustre, Your Honor, that would be the case. One, Lustre would be bound to this court from the district court by the holding that A&S has sovereignty against Lustre's claims. I mean, so with respect to Lustre and tribal court, yes, A&S would be able to assert any viable defense to sovereignty. But sovereign immunity, of course, it depends on who the claim is. Lustre, again, is a complete stranger to A&S. A&S had no idea who Lustre was until it showed up and sued A&S. And so sovereign immunity, it does depend who's bringing the suit. The lessors have never come forward to and obviously they have a contractual relationship.
So the lessor, sorry, go ahead. So the lessors could sue in tribal court?
They could certainly bring claims against A&S, and it would look to the lease, and it would be resolved on that basis. Again, those lessors obviously have contractual relationships with A&S. The tribes honors all its contractual obligations. That's how that works.
So let me follow up on that question because it deals with whether plaintiff here has a remedy. The U.S. Supreme Court, or a number of the justices, particularly in the Bay Mills case and the dissent, discussed the problem of the proliferation of commercial activities by tribes and the consequences of the extension of sovereign immunity to cover all of the tribe's commercial activities. And those justices said tribal immunity significantly limits and often extinguishes the state's ability, of course, states are sovereign also, state's ability to protect their citizens and enforce the law against tribal businesses. The problem repeats itself. Every time a tribe fails to pay state taxes, harms a tort victim, breaches a contract, or otherwise violates state laws, and tribal immunity bars the only feasible legal remedy. Isn't that what we have here? a situation where the tribe has created a corporation to engage in commercial activity off the reservation under the auspices of another sovereignty, and yet wants to evade any sort of legal action arising from those activities?
Justice Rice, first, the dissent does have the discussion in Bay Mills. Nevertheless, the Supreme Court held whether to fix tribal sovereign immunity as a matter for Congress. Now, with respect to a lot
And
of
it involved an actual tribe, not just tribal corporation.
correct. The other, the issue of the state having to enforce laws, stuff like that. I mean, those are situations where they would be dealt with differently. I mean, again, no one here is alleging that A&S did anything wrong to Lustre. I mean, again, A&S has no relationship with Lustre. To the extent there's a tort victim or the state is trying to assert jurisdiction over A&S, I mean, that just presents a sort of different issue in terms of how a remedy could be, a claim could be brought against A&S and how that works. So I think just broadly, A&S is not trying to skirt liability for anything. I mean, it's just, again, with respect to Lustre, who has no prior involvement with A&S, it's asserting a viable legal defense to those claims. So to address the formation under Delaware law, and I would like to touch on Justice McKinnon's discussion earlier about. I would also like to highlight again that White was a state corporation, and the Ninth Circuit found that that entity was entitled to sovereign immunity. Counsel for Lustre makes this argument that a tribe first needs to create a tribal corporation, and then it can create a state. I mean, that doesn't. In all cases, the immunity always derives from the tribe itself. The tribe does not need to create a tribal corporation to create immunity. And so the issue in all these cases, regardless whether it's a state corporation or it's tribal law or state law, is what is that entity's relationship to the tribe? And if anything, if a tribe first creates a tribal corporation, I mean, that just creates more sort of another layer essentially between the tribe and the state entity. So White is just clearly there. I'm not aware of anything in that case that suggests that that committee had incorporated under tribal law. I believe it was formed solely under or state law. And the Ninth Circuit again found that that entity was entitled to sovereign immunity. It relied, like Justice McKinney referred, on the precedent that incorporation or state law is not to vest the entity of sovereign immunity. And I'd point to the McCoy cases, which again, the defendant was the state corporation, which was a separate entity in the McCoy. Both the Ninth Circuit and the District Court in McCoy acknowledged that the state corporation was a separate entity, and it didn't matter that the tribe had formed a tribal corporation. Because again, that wasn't the defendant in the case, and that wasn't where the sovereign immunity derived from. So we do think the court should follow White. There is this court's McPhee case, which says deference should be given to Ninth Circuit decisions. Again, the Ninth Circuit isn't binding, but White is a factor test. It's not a bright line rule. We think it's more appropriate, particularly with respect to tribal sovereign immunity, which considers lots of things such as economic development and really important purposes for tribes.
Let me ask you about the factors in White then. I mean, the district court ran through all of the 5 factors and then just seemed to ultimately include sovereign immunity wins 3-2. It's not clear to me from White or Breakthrough that it's that you tally up the total of the 5 factors, that it's more of a holistic endeavor in terms of how heavily one factor may weigh in favor or against. I mean, can you speak to that?
Correct, Your Honor. I guess the Ninth Circuit has 5 factors, the 10th Circuit has 6. I mean, but what I think is good about the Ninth Circuit is the whole analysis is informed by what are the purposes and principles of tribal sovereignty. And it is a little bit different than how it is for federal government and state governments. And what informs the entire analysis This idea of tribal sovereign immunity is to promote self-sufficiency in economic development of tribes because they face a lot of barriers with a lack of a tax base, stuff like that. So these enterprises are not just a business venture. They are the means by which tribes can raise revenue to fund their government. So that informs the entire analysis. And that's where I think this district court was correct to find that second factor weighed heavily in favor of immunity because tribes, they're not acting for a private business interest. There's a reason why they're doing this. They don't do this to enrich private individuals. This would be the case. This was just a normal business.
Wouldn't that be true of all tribal corporations? If that were the case, if that were the guiding principle, we wouldn't need 5 or 6 factors, it seems.
Just that is true, but you will see in some of these cases, and I think this is where the 5th factor is actually a good one to look at, is some of those cases, and I think it's People versus Miami Nation. There's sometimes where the revenues really aren't going to the tribes. You know, they have business partners, and you know the tribes are really only seeing a small percentage. In those cases, the courts are like, why should we give this entity sovereign immunity? Because the tribe is not really the one benefiting from this relationship, and that's where Lustre wants to focus on this idea of direct liability, and how much of the tribes, the minutia of the tribe's budget. But that factor focuses again on the percentage of the overall revenues. And here, there's no dispute that all of A&S's profits go to the tribes. So the 5-factor test, it's not just as simple as, well, the tribe has a business entity. There are other aspects of how that entity works in its relationship to the tribes that is important to pay attention to. And again, like I said, just the diversion of revenues is a great example. Again, here, there's no dispute. All of A&S's profits go to the tribes. The tribes use that revenue to fund the government.
But Mr. Murdoch, to follow up on that 5th factor, I think the argument is that the court only looked at that one fact that the revenues go to the tribe, but your statement just acknowledged that it looks at the proportion. I mean, we don't know how significant it might be to the tribal government or the tribal operations. And I think the case law suggests that no, we should not probe the minutia of tribal finances, but there should be some evidence regarding how meaningful this revenue is or what kind of contribution it makes. And is there anything in the record that would help us look at that question? Or do you disagree that we should?
Let me take the last point first. I do think this is a little misunderstanding. It's actually, it says the percentage of the entity's revenues. And what that means is, and a good example is the California Supreme Court case. It's People versus Miami Nation. How that got applied was, it's not looking at, well, what is the revenue, the entity's revenues percentage of the overall tribal budget, but how much of the entity's revenues itself go to the tribes. So it's the percentage of the entity's revenue. Because again, if the tribe is really only getting 3% and 97% is going to a non-Indian business partner, what is the benefit to the tribe? So I would just first say that I think that's really the correct way that should be applied. Now, with respect to the tribe's overall budget, I mean, with respect to the facts, I mean, we just looked at a brief period in the district court when this was going on, from October 2020 to January 2021, and A&S had provided $104,000. Council suggests that might be insignificant, but again, this is a remote reservation. That is a significant amount for the tribe's government. Now, I know Lustre in its brief pulled out some COVID relief acts, which wasn't considered. 2, that actually just shows the need to get that access to that funding. The tribes have to show. And those funds have limitations on how it can be used. So the tribes, just like any other tribal government, needs to supplement that because they're. So we would suggest the $184,000 over just a 4-month period is significant. If the court wants to sort of look at, well, how much is this to the tribes? Now, the tribes obviously didn't submit their budget for the district court to sort of comb through. Lustre asked for and received jurisdiction. Could have developed that information. Thought it was not. So that information is not in the record, but as Justice said, courts really don't see that as a predominant factor in analysis. Let's look through the tribe's budget. So it's just to circle back real quick, just to the first issue of whether it's dispositive that the tribes formed under Delaware law. And it's not. Summer law was dicta, as I think we all, as was discussed earlier. That case was actually not even, that issue is not even particularly litigated. If you read that, the 10th Circuit, most of the discussion is talking about how painful it was because the plaintiff was not really even making it. So it was just supplemental briefing. There really wasn't any sort of adversary presentation of the issues. And if you look at, we cite Vassy, which is the district court for Maine. It actually considered summer law. It considered the other side. It actually found that the case law is not as simple as summer law tries to make it out to be. There's a case, LeBron versus National Passenger, which involves a track, which is a United States. In that case, the Supreme Court looked at that entity and said, this is part of the government. So we do think that this court should affirm that this court correctly followed White and applied to factors.
So in that regard, the incorporation in Delaware is relevant to the first White factor.
Correct. It's the method of creation. The district court concluded that weighed against sovereign immunity. We argue that district court should have found it in favor of immunity, but that's why the factor test is more appropriate, because it sort of puts those issues that they do get covered in the analysis. Maybe covered in the first step. So we've talked about the first factor. To the second factor, A&S's purposes have always been to develop reservations with oil and gas resources. There was, a bit of discussion earlier about A&S's waiver of sovereign immunity in Exhibit B to the Fort Peck Energy Company operating agreement. And just to talk about that, again, that is a completely different agreement that is extrinsic to A&S's foundational documents. A&S was formed pursuant to a tribal business executive board resolution, and then the governing document is A&S's operating. Fort Peck Energy agreement is a completely separate agreement. We cited in our brief. This court recognizes that operators are just a contract. So that's what the Fort Peck Energy Company operating agreement is. And Justice Sandiford, you mentioned the context. And I do think the context should be considered when you look at that agreement, because if the tribes had some general intent to disclaim sovereign immunity, why was that not in A&S's operating? One would imagine that's where it would show up if that was a general sort of intent of the tribes. But that's not where it shows up. It shows up in a completely different contract and terminated.
If I can follow up on that, the operating agreement isn't a contract with anyone. It's the formational document for A&S. So, and it specifically talks about A&S's assets being subject to a claim to shield the tribes. So it's not, I would say it's not a clear waiver, but looking at it in the context of the 5 factors, how does it weigh? I mean, it does show that the tribes intended the assets of A&S to be available for claims against.
It intended that I would flip it. What it shows is that they wanted the tribes assets, not which is a characteristic of any.
Kind of the same, it's the other side of the coin maybe, but it shields one and doesn't shield the other.
Well, I do think the district court sort of dealt with, I believe this is 10.9 of A&S's operating group. The district court correctly sort of dealt with this. She found, at best it needs to be expressed. It's sort of this type of a provision in an operating agreement is not unusual. Just the idea that you're separating the owner's assets from the entities. It does say that it could be subject to claim, but again, whoever's going to try to bring those claims would need to have. So I just think the district court correctly resolved this issue, finding that at best it's not an express.
I guess I'm looking at 10.9 and I just can't see how that's not an express. Any agreements, obligations, and transactions entered into by the company shall be solely for its account of its assets shall be subject to any. No event shall the tribes have an obligation subject to any claim with respect to it. It's titled sovereign immunity of tribes.
I mean, it reserves the tribe sovereignty to make sure it's not. But I mean, it just talks about any claim. Any claim needs a waiver. I would, and if you want to compare it to the Fort Peck Energy Group, which had a fairly express statement of a waiver, I just don't see the comparison. So I think 10.9. So to the purposes, counsel talks about how, the district court erred in not considering sort of the factual circumstances. Now, A&S, like as I mentioned earlier, A&S does not act in private interest. And so when it's wanting to engage in oil and gas development, the district court correctly looked at the context of why the tribes want to do this. And one of the reasons was the past environmental degradation on the reservation. The tribes have worked very hard to assert control over the reservation to fix those problems and address those problems. So future oil and gas development, that would not reoccur. And again, when the idea that they were seeking business partners, the tribes don't seek business partners for the sake of doing business. Again, they are doing it to generate revenue to fund the tribe. So we think the district court correctly looked at factual circumstances. And there are examples of that. There's the Fourth Circuit case in Defendants where the Fourth Circuit didn't just look at the plain text of the documents. It sort of considered what was going on and why were the tribes creating these entities. There it had to do with payday lending, which is but it was the same sort of analysis where the court said, well, why is the tribe doing this? And so when you look at the resolution, it does say the tribes want to proceed with gas development. But to understand why they're doing that, you have to understand the actual circumstances. So we do think the district court was correct. Moving on to the third factor, counsel for Lustre really emphasized that the tribes were separating A&S from the tribes. Again, every entity with limited liability, that's a purpose. Courts have found, with respect to the armored tribe analysis, not dispositive. It's not even. And Lustre focuses on this October 2020 resolution, which said that the tribes want to separate. And let's just look at this resolution. And everything about this shows the degree of control that the tribes exercise over A&S. But first, the TB invoked its authority in A&S's operating agreement, which provides that A&S's powers and affairs are managed and directed and approved by the tribal executive board. Also in this resolution, the tribal executive board appointed 5 officers for A&S to carry out the tribal executive board's direction. Next, the Tribal Executive Board authorized A&S to establish a checking account and further approved A&S to withdraw funds to cover new wells. The resolution also authorized specific expenditures. It authorized a $1 million loan from the tribes to A&S, and it authorized the tribe's chairman to execute the loan on behalf. So this might say it was separating, that one clause there, but everything about this resolution shows the tribes are enmeshed in A&S's activities and operations. So under the third factor, the district court correctly concluded that it weighed in favor of the community. I think this court should find ways heavily in favor. A&S is exclusively controlled by the tribes. They appointed Debbie Madison as the general manager. Lustre tries to say that somehow was against immunity. She's been a tribal employee for about 30 or 40 years. She's going to get mad because I get the years wrong, but that is a way in which the tribes exercise control.
Council, before you run out of time, I did want to circle back to one of the last things that Lustre's counsel had spoken of, which was going back to the acknowledgement and waiver of sovereign immunity, the distinction between point number one, which is an acknowledgement that the tribe's holding company does not and shall not be construed to possess sovereign immunity, as opposed to a waiver, which may be constrained to the operating agreement that was entered into. But number one, is there a distinction there? I mean, there's an acknowledgement as opposed to a waiver. Just an acknowledgement seems to be just that. That A&S is acknowledging it doesn't have sovereign immunity.
With respect to the Fort Peck Energy, I think there was discussion earlier about these business partners wanted to leave no doubt that their contractual obligation. So this is the result. So it is fairly prominent.
But that kind of goes to point number two that begins with, in order to remove all doubt in this regard, almost kind of a belt and suspenders. We're saying at least Lustre's argument is, as it pertains to this, number one is saying we don't have sovereign immunity. We're acknowledging that. But if you have any doubt as to that, we'll expressly waive, and that there's a distinction between those two. What's your response to that?
I don't think there's a distinction. I think it just needs to be viewed in context of these business partners wanted to resolve it. And so if they ever had an issue that they wanted to sue A&S, they wanted to point to this as broad language as possible. So you can't even. So that's how I would view this. Lustre is not a party to this agreement. It's terminated and cannot rely on this waiver. And again, if you look at the context, if to the first point there was an acknowledgement that never existed, it should have been an A&S. That absence is significant. Since I am running time, I briefly wanted to touch on the first question about environmental responsibility. Again, immunity cases are addressed on case-by-case circumstances. A&S does have sovereign immunity against Lustre's claims. With respect to environmental, there's a whole system of remedies that come into play. The federal government has a role. So it would be very different. This case, again, is about a plaintiff who has no relationship with insurance, no relationship with A&S, no relationship with the reservation. And the simple fact is its case got dismissed because it doesn't have any sort of relationship. There's no basis to overcome A&S's sovereign. I'm running out of time. And just in conclusion, courts should affirm the district court's dismissal of Lustre's lawsuit. The tribes created A&S to serve the tribe's critical goals, self-defense and economic development. Tribes retain exclusive control over A&S and receive direct benefits from A&S's operation. A&S is arm of the tribes, sovereign immunity bars Lustre's.
Works. My mic count 7 minutes.
Very good. Thank you. Getting back to you, I think one of the last questions we addressed, can they get confused? I think the answer absolutely is yes. It's a freedom of contract issue. Every contract they enter into, they have this right to either waive sovereign immunity or in this case, acknowledge, not waive, acknowledge, and they never have sovereign immunity. That's what they did here. It's not that we are, or number two, you're getting back to that specific acknowledgement. It's an acknowledgement that we don't have the right to even assert we have sovereign immunity. So they're just eliminating all of these layers of doubt, entering into that document.
But there's no contract here. There's no relationship.
This is a separate and distinct acknowledgement executed by the tribes 2.5 weeks after the execution of that agreement. I think it was to eliminate all doubt. We are not a sovereign entity. So we think that's very important because A&S, when they executed that document, they couldn't make sovereign immunity through that document. It had to be done by the tribes. But the A&S cannot waive this. It has to be the tribes. That's why they acknowledge it. I also want to get back to your question of whether or not they could be immune from a certain oil spill related to one of the oil and gas leases. Unless they have an express waiver in that oil and gas lease and that service agreement, I think it would be yes. As we talked about in section 110, and they don't dispute, they cannot be sued in tribal court any more than they can be sued in federal court or state's district courts in Montana, because that's significant. We believe that is consistent with the underlying purpose upon which A&S was created, not some later defined purpose 12 years later. Look at the formation of documents out of the purpose. And we also take issue that we're a stranger to the reservation. We have real property interest, oil and gas leases with these private individuals within the reservation. That's why we're here. Those are real property rights. Those are within the reservation. There's a dispute over them. So we take issue with the fact that we have a relationship with the tribe and the reservation. We'll certainly have real property interest. Those entities, those individuals who live or own mineral within the exterior boundary of that reservation. And as it relates to some of these other cases, whether it's Rossi or McCoy, J.O. Ward, I don't think our argument is based to summarize that you have to create a tribal first. In a lot of these cases, that's what happens. I don't think that was the holding in Summerlin. I think the holding in Summerlin, well, the analysis in Summerlin is not a holding. That if you want to make the free choice to go to a separate sovereign, separate state, you voluntarily do that, you're going to lose the right to claim sovereign immunity back in another sovereign perspective. And we think that's why it's most important, because it's not that you had a tribal corporation first. In our mind, that's not really the relevant point. The relevant point is that in this instance, Summerlin, they made the choice. That choice should be respected. And that choice comes with consequences. And you have to live with those consequences. That's the foundation of documents. And as it relates to the McCoy case, that was a tribal college. I think that's something quite different when you have a tribe-owned tribal college versus a for-profit company that is out here operating oil and gas wells on land that is subject to the MUOG jurisdiction. That's quite different. That's one of the distinctions. There was some discussion about the financial situation. We also would maintain that under the Miami Nation case, that case is very clear. We must show more than some revenue goes to the tribe. And that's all the district court did here. It just looked at that one particular factor and said, there is some revenue, $60,000 a month, $180 over a couple of months that goes to the tribe. We don't think the district court properly looked at and considered the degree as to all of those factors. So under that Miami Nation case, which is what the district court relied, we have to do more than just show some revenue. There's been no evidence provided that 60,000 is significant. None. We have no idea. All we have is the.
What about to council's point that, I mean, you're really looking at it, 60,000 is 100% of A&S's revenue. Then that's the factor, or that's the context of the factor, rather than what percentage does 60,000 represent in the entire revenue stream to the tribe.
I don't think that's the thing. I think you have to look at the degree and the amount. And I think that's what Miami Nation is saying. You don't just look at the percentage of how much money is going into the tribe. You have to look at it in a broader context.
Did you conduct any discovery on that issue?
We did. I mean, what we asked them for this information and they refused to give it. As part of our jurisdictional discovery, we did ask for this type of information. They refused to give it. We filed a motion to compel, and it was denied. There was a lot of jurisdictional discovery and motion practice. We asked for this type of information. We were not given access.
So, and I'm not clear, is there a dispute though that that 100% of the revenue goes to the tribe? Or is the dispute, what percentage does that revenue represent in terms of the tribe's overall budget?
I don't think there's a dispute that 100%. I think that's in the operating agreement. There was also some discussion of the Rossi case. In that case, obviously, it's very different. In that case, the entity Indian Reservation wasn't immune because of the summer lot issue or the type of issue. In that case, and in that statute, it provides that subsidiaries and other types of things are immune based on that. And as it relates to the path environmental degradation, we're not saying that should not be looked at or that's unimportant. Those things happened 50 years ago, 70 years ago. That's what the district court is talking about. So as it relates to what's happening now, that's what these resolutions say. The organization. We think that the most important document is the acknowledgement. Acknowledgement says we do not possess sovereign immunity, and never assert the right to sovereign immunity. See, my time is up, but thank you very much.
With the